The response we've all been waiting for. The state has filed their response to Alex's motion for a new trial and added the state's motion to strike. It's magnificently written, and I thoroughly enjoyed this read. I'm just going to read paragraph 2 as my introduction today because I can't say it better than this. It says, Murdaugh broadly claims that he's entitled to a new trial based on allegations that the clerk of court of Colleton County, Becky Hill, improperly attempted to influence the jury's decision. In support of his claim, Murdaugh offers affidavits from one juror who participated in deliberations, one who was removed for dishonestly concealing her own improper communications about the case, and 2 hearsay affidavits from his counsel's paralegal. Murdaugh additionally advances a sweeping conspiratorial theory about wholly irrelevant Facebook posts with scant evidence to support it. Team Alex made some wild accusations about claims the jury made, how things went behind the scenes, and about Clerk of Court Becky Hill, and that nonsensical Facebook story. When we hear the actual story unfold, I feel bad at how Becky Hill's name has been dragged through the mud. We hear the truth about what the jurors have to say and the sequence of events as they actually happened. It really clears things up and shows just how far Dick and Jim will go and care not who gets hurt in their wake. I have a whole new level of disgust for them, and now, after reading this, I can't wait to hear how the state's going to defend Judge Newman from this writ of prohibition. Are you ready to hear the response? Let's get started. This is Legal Updates with Cassidy. The state's response to Alex Murdaugh's motion for a new trial. Part 1. Be careful when you quote Dick. Welcome. Sorry about my voice, guys. I've had such a sore throat these last few days, and it's really affecting my voice. I'm going to go as far as I can with this today. I know I won't be able to finish, but it's really such a juicy document, and I've been so excited to share it with you. But first I had to finish the podcast on the writ of prohibition, so I just didn't want to put it off any longer. This document begins with a brief outline of the facts. That Alex was convicted for the murders on March 2nd, 2023. That he was sentenced to 2 consecutive life sentences without parole on March the 3rd. He then filed a notice of appeal, but then on September 5th of 2023, he filed a motion to suspend appeal and for leave to file motion for new trial. The Court of Appeals granted this request on October 17th and remanded the matter to this court to permit Alex to file his motion, which he filed on October 27th. Then we move on to Part 1, Law and Procedure. Colorable claims of after-discovered improper external influence on a jury may necessitate a judicially conducted inquiry to confirm the validity of the verdict as free from external influences, through which defendant must show actual prejudice. Colorable claims are plausible legal claims. That means that the claim is strong enough to have a reasonable chance of being valid, that the legal basis is generally correct, and that the facts can be proven in court. So this is basically stating that Team Alex jumped the gun here. Maybe not just jumped the gun, but ran a whole lap before the gun even fired. They skipped so many steps and went straight to, we demand a new trial, ignoring the legally established process of how to deal with these situations. And that's what this section will deal with. They begin, the law permits, but skeptically receives motions for new trials based on after-discovered evidence, and never does the law permit highly motivated convicts to put their own jury on trial. And then we see the same quotes and cases that were previously mentioned in State's original response to Alex's request to put his appeal on hold to request a new trial. You know, that motion they were so proud of, they all put on their sunglasses and held a whole press conference for when they filed it. Let's see the intelligent answer to that nonsense. They quote from State v. Kelly that says that criminal defendants have a right to a fair and impartial jury, and private communications or contact with jurors during a criminal trial about the matter pending before them may necessitate an evidentiary hearing, and if the defendant can show actual prejudice, a new trial. So this backs up the title of this portion of the document. To understand the next quote, we have to flip back to Alex's motion for new trial, where in their legal standard, they quote Rimmer versus United States. You're going to hear a lot about the Rimmer case today. Rimmer was a case where a juror was offered money for a certain verdict, which is without question jury tampering. This case set legal precedent and has often been referred to anytime the subject of jury tampering arises, and defense has quoted it as the basis for demanding that Alex has a right for a new trial. So keep that in mind as we go through all of these cases and documents. Now the state responds by citing State versus Green. State versus Green was a rare case in 2020 where a writ of certiorari was granted and a review of the Court of Appeals decision was held in the state Supreme Court of South Carolina. A writ of certiorari is like the writ of prohibition that Team Alex filed, addressed to the Supreme Court. In this case, it's a request for the Supreme Court to review a lower court's decision. Most of these are not granted. And much like the U.S. Supreme Court, they select ones that have significance, such as precedential value, which means the ability to establish a legal precedent, which is probably why this case, State versus Green, was chosen. Rimmer has been used as a precedent for these cases, but State versus Green was a situation that led to a distinction in cases under that Rimmer blanket. In the Green case, there were two issues. The first was, ironically, about a social media post, but the trial court's decision on that was immediately admitted without comment. The second, the issue of improper communication between a bailiff and a juror, was the point that they focused on. They quoted the court's decision on Rimmer, just the one we just read, but added, "We are not persuaded that the Rimmer presumption of prejudice applied here." And why was that? Here's the explanation. They state, "We readily agree with the Court of Appeals that the state overthrew any presumption of prejudice, if it applied. In this regard, we join the Court of Appeals in commending the trial court for its deft handling of this issue. The trial court questioned each juror and the bailiff, which proved there was no reasonable possibility the bailiff's comments influenced the verdict. Our unwillingness to categorically apply the Rimmer presumption of prejudice stems from our view that not every inappropriate comment by a bailiff to a juror rises to the level of constitutional error. In Rimmer, a juror was approached by a person unnamed and told that the juror could profit by bringing in a verdict favorable to the defendant. The federal district court, without holding a hearing, denied the defendant's motion for a new trial. Ultimately, the Supreme Court recognized the presumption of prejudice from the highly improper juror contact and remanded to the federal district court to hold a hearing to determine whether the incident complained of was harmful to the defendant. So that's the background of this Rimmer case we keep hearing about. They go on, the attempted bribery of a juror in Rimmer, conduct which goes to the heart of the merits of the case on trial, is a far cry from the circumstances presented in this case. The bailiff's actions here, though improper, do not touch the merits, but dealt only with the procedural question of how the judge might handle a jury impasse that apparently never materialized. Here, the jury deliberated approximately 4 hours before reaching a verdict. The jury never indicated it was at an impasse. At some point in the deliberations, a juror asked the bailiff what would happen if the jury were not able to reach a verdict. The response by the bailiff, while inappropriate, did not rise to level of a violation of petitioner's Sixth Amendment right to a fair and impartial jury. And that was the answer from the Supreme Court. We'll also get to the appeals court discussion on that a little bit later. And at the conclusion, they mention again, we decline to adopt the Rimmer presumption of prejudice in every instance of an inappropriate bailiff communication to a juror. The Supreme Court unanimously decided that Rimmer was not applicable to the Green case, which is very similar to Alex's case, even the time it took the jury to deliberate, which is another aspect that Team Alex mentioned. But I think reading this Supreme Court finding gives us a view into how the Supreme Court will see Alex's case. Now back to the state's document. After citing the quote I just read, not every inappropriate comment by a member of court staff to a juror rises to the level of constitutional error. Quoting from the Phillips case, it says, were that the rule, few trials would be constitutionally acceptable. And then State versus Grovenstein, jurors are presumed to follow the law as instructed to them, to include instructions of what constitutes proper evidence to consider in deliberations, and such instructions are usually deemed to have cured the erroneous exposure to improper evidence or argument. That statement both puts responsibility on the jury for upholding their oath and also puts faith in the jury that in spite of anything they might get exposed to, whether inside the court or outside the court, the instructions given to them by the judge should be enough to override that information. And then we see this footnote at the bottom that cites many cases where federal courts have decided not to apply Rimmer and the reasons for it, stating that federal courts are hardly consistent in interpreting and applying it. United States versus Johnson, for example, said that not all communications with jurors warrant a hearing and that the defendants must show that unauthorized contact created actual juror bias. Smith versus Phillips, if a defendant makes a threshold showing of a credible allegation that an unauthorized juror contact was made, they are entitled to a rebuttal presumption of prejudice and an evidentiary hearing to determine what actually transpired and whether what actually happened was harmless, saying that the defendant must prove actual bias. And in some cases, the Supreme Court has held that Rimmer is not a constitutional rule at all, saying that Rimmer more naturally could be read as a case about new trial motion practice under the federal rules of criminal procedure than as one about requirements of constitutional due process, basically saying that Rimmer has been given more power than it ought to have been given. Next, we have the rule that Team Alex based their motion on, and that's Rule 29B. In the cited case, State v. Caskey, the Supreme Court gave 5 conditions as the only reasons for this after-discovered evidence to allow for the granting of a new trial. 1 is such as would probably change the result if a new trial was had. That's one criteria. We're going to skip 2 and 3 and get to 4. Is material to the issue of guilt or innocence. And we'll also skip 5 because those 2 are the important points that they're trying to make here. So rather than this thought that any time there's an accusation against a person of the court and the jury, it's not an automatic retrial applying Rimmer. There are other methods available, such as the evidentiary hearing. We saw that mentioned just now, but there are also steps to take before an evidentiary hearing. What are they? It starts with prima facie, which means at first sight or at first glance. This is a pre-trial evidence that's reviewed by a judge and determined to be sufficient or to have enough merit to warrant the trial. Now, in this case, we're not talking about a trial, we're talking about a hearing, but it's the same standard. Is this evidence sufficient or does it have enough merit to warrant a hearing? According to State v. Linder, a simple jury poll may cure any procedural irregularities and confirm that each juror approves of the verdict returned and that no one has been coerced or induced to agree to a verdict to which he or she does not actually assent. This case is cited here to reinforce the importance of jury polling, but I got really wrapped up in the story of this case. It's very interesting reading through, and it caught my eye because I saw a very familiar name indeed, Randolph Murdaugh Jr., as in Alex's granddad, the original buster, in his capacity as solicitor. This man, Michael Linder, was found guilty of larceny and murder of a South Carolina highway patrolman, and he was then sentenced to death. But there were several things wrong with his case. Linder was speeding on a public highway on his motorcycle. Patrolman Peoples pursued him and a long chase ensued. The rest of the story was disputed. The state claimed that Patrolman Peoples overtook him, began the process of arresting Linder, when Linder suddenly took his revolver that had been concealed and shot and killed him, and ran away to hide, but was tracked down and apprehended. Linder's version was that Patrolman Peoples bumped his motorcycle with the patrol car, knocking him down and causing his revolver to come out of the leg holster. Upon seeing the gun, he alleges that patrolman Peoples began firing on him. He then grabbed his revolver, shot the patrolman, panicked, and fled. Linder pled self-defense and his counsel requested voluntary manslaughter as a possible verdict, but the court refused, sticking only with the murder charge as possible. The Supreme Court ruled that this was error by the trial judge because although manslaughter cannot be on the table in a normal arrest, it can if the terms of that arrest involve unnecessary violence, such as the patrolman bumping his motorcycle and shooting at him first. But that wasn't the big issue. The big issue was that during the sentencing phase, Linder requested a jury poll to ensure that every juror agreed to the recommendation of the death penalty. But the judge refused, saying that the four-person's word was good enough. The Supreme Court disagreed because this is the right of the defendant. They reversed the guilty verdict, removed the death sentence, and demanded a retrial. In the retrial, it was a ballistics report by SLED that discovered the 6 casings were fired from the patrolman's gun, proving Linder's version of events. This evidence had not been available during the first trial. Linder was acquitted on November 9th, which makes today the 42nd anniversary of his acquittal as I write this podcast. Other interesting facts of this case are that Solicitor Buster had to be cautioned by the trial judge during his arguments. We see it's alleged that his argument was so prejudicial it denied him a fair trial, and that at one point in the solicitor's argument, the trial judge warned him that he was getting a little far afield. This wasn't just a case of defendant grasping at straws, since it was acknowledged by the Supreme Court justices. He had to be cautioned against personal bias, which is funny that that's what his grandson is now claiming, and also against being so calculated as to arouse passion or prejudice. And the Supreme Court also stated that Buster's improper arguments were thoroughly reviewed, but they declined to comment on them since the case was to be retried anyway, making his improper arguments invalid. They did go on to admonish Buster that in the future, he needs to stay within the record and its reasonable inferences. So apparently, he got out of line during his arguments in this case, had to be reprimanded by the judge, and again, admonished by the Supreme Court. The point of citing this case, however, was the importance of polling a jury and what such a poll establishes, because it was a lack of polling that caused this trial to be noticed by the Supreme Court, as it is a right of defense. So the important statements by the Supreme Court for this case are: polling is a practice whereby the court determines from the jurors individually whether they assented and still assent to the verdict. Which we know in Alex's case, there was a poll reading. All of them voiced this was their verdict. It further comments, we establish this rule to dispel any doubt a party might entertain as to the propriety of a jury verdict as rendered. So basically, once the jury is polled and each individually say, this is my verdict, it stands. So jury polling is a very important legal process. And I think what the state is suggesting here is that the first place to begin is to have a jury poll. And this will be the prima facie evidence. And then if that poll suggests that an evidentiary hearing is required, it is a strictly limited, judicially conducted affair. And they quote from Rules of Evidence, which reads, upon an inquiry into the validity of a verdict or indictment, a juror may not testify as to any matter or statement occurring during the course of the jury's deliberations, or to the effect of anything upon that or any other juror's mind or emotions as influencing the juror to assent to or dissent from the verdict or indictment, or concerning the juror's mental processes in connection therewith, except that a juror may testify on the question whether extraneous, prejudicial information was improperly brought to the jury's attention, or whether any outside influence was improperly brought to bear upon any juror. Nor may a juror's affidavit or evidence of any statement by the juror concerning a matter about which the juror would be precluded from testifying be received for these purposes. So clearly, it's not an anything goes situation. Judicially conducted affair means before a judge, and these rules clearly state certain subjects are forbidden from being questioned. Now we come back to the Green case we reviewed earlier. If you remember, the Supreme Court determined that the federal district court must hold a hearing to determine whether the incident complained of was harmful to the defendant. How was that done? We find this in the Court of Appeals case for this matter. In Section 3, Bailiff Misconduct, they quote Rimmer just as Barber did in his angry motion, but they stood there in their sunglasses at the press conference, making the bold statement that the court has no choice. They must grant Alex a new trial based on Rimmer. And I have heard this since repeated over and over. No choice. If Becky did this, Alex gets a new trial. But right here, in black and white, this is simply not true. In this case, decided by the Supreme Court, an evidentiary hearing was held, and it bore the answer that no new trial need be granted. Because even though this bailiff, court staff, spoke inappropriately, it did not affect the verdict. Let's look. It says both the Supreme Court and Court of Appeals commended the trial court's deft handling in Green for the process it followed in investigating its own allegations of improper communication between a bailiff and a member of the jury. The trial court questioned each juror and the bailiff, which proved there was no reasonable possibility the bailiff's comments influenced the verdict. More specifically, the Honorable Donald B. Hucker, immediately after publishing the verdict, cleared the courtroom of all present, save the lawyers involved in the case, the clerk, and the judge's staff, then brought out each juror individually and pulled them on the record, asking the following questions. Was your verdict guilty on both charges, and is that still your verdict? Was your verdict based 100% on the testimony, evidence, and law presented at this trial? Was your verdict influenced in any manner by any communications with any of the bailiffs or any other persons outside of the 12-member jury? Did you have any communication with any of the bailiffs or with a third party not part of the jury? And if so, please relay to the court what those communications were. This is very much like the way the jury was questioned here in this provided document. I've already read to you the jury's statements a couple of days ago. There's going to be a little bit more information on the poll that they took at the end of this document that we'll get to later. But in this case, State v. Green, brought before the Supreme Court specifically because of improper communications between a bailiff and a juror, this was the way it was handled, praised by both the Court of Appeals and the Supreme Court for this way it was handled. There was no new trial, and in the Court of Appeals decision, they make comments about this. I read the ones from the Supreme Court, and then I told you I would read these. These comments say, the scope and currency of the Rimmer presumption has split the federal circuits, but it remains alive and well in the Fourth Circuit. Skipping down, while Rimmer requires us to presume the bailiff's blunder prejudiced Green, we conclude the state overthrew the presumption by proving there was no reasonable possibility the comments influenced the verdict. We reach this conclusion for several reasons. First, the trial court found no evidence the comment was communicated to anyone but the foreperson. This holds the number of jurors exposed to improper communication relevant to determining whether misconduct influenced jury. We also have that situation. We had one juror, I believe, that stated that they might have thought that Becky mentioned something about Alex's body language. So this is another similarity in these cases. Not every juror was affected by the improper communication, or in Becky's case, the alleged improper communication, because her allegations are just allegations at this point. Nothing has been proven. Second, there's no evidence the jury was ever deadlocked or even having difficulty reaching a verdict. This is also true with Alex Murdaugh's case. Third, the bailiff's comments, while astonishingly inappropriate, did not reference facts about the case. Again, the allegations against Becky are that she warned people of the graphic nature of pictures they were about to see, and one or two jurors mentioned that she said something about watching his body language. These are not facts about the case. Fourth, none of the jurors testified there was any communication with the bailiff other than about incidental administrative matters. The trial judge took this to mean not even the foreperson perceived the bailiff's remark as worthy of attention or remembrance. Fifth, all of the jurors testified there was no extraneous influence on their verdict. This is also the same with the jurors' comments in their polling by sled. The final comments by the Court of Appeals judges, we commend the trial court's deft handling of this issue, same as what the Supreme Court said. Because the evidence excludes any reasonable possibility that the bailiff's misconduct influenced the jury's impartiality or its verdict, the trial court did not abuse its discretion in denying Green's mistrial motion. So, ladies and gentlemen, there couldn't be a case more similar. A case that went through Supreme Court, a case that went through appeals. Both courts decided that this polling of the jury was sufficient to handle the accusations. In this case, the bailiff's inappropriate comment was factual. In Alex Murdaugh's case, they're all allegations that she denies, and nearly the entire jury denies as well. So, again, as they stood there in their sunglasses, telling the world that the court had no choice other than to grant Alex Murdaugh a new trial, and all of the people who have repeated that since, it's simply not so. And there's plenty of documentation here, in this case held in South Carolina just 3 years ago. In fact, it was so recent, it was the same Attorney General, Alan Wilson, but also a slew of federal courts that have come to this same conclusion. So basically, Team Alex tried to skip 4 steps ahead by demanding a new trial. But we're going to have to stop here today so I can rest my voice. I will get to the rest of this document. Isn't it juicy? It's so juicy. I hope you're loving it as much as I am. And I'm sorry to break it up and stop here after you've been waiting, but that's just the way it's got to be for today. I'm very much looking forward to getting through the rest of this document with you. This is only page 5 of 25 pages, so it may take more than 2 parts this time, because I am really savoring it. I hope you are too. So until next time, this is Cassidy O'Connell saying stay well and stay tuned. First, I've got to get well, and then I'll stay well. But I hope you're all well.